Hello, everybody. Thank you for joining us for our first IP section CLE of the year. Hopefully we'll have more. And I'll go ahead and turn it over to Halina at this point. Thank you, Halina.
Okay, thanks, Bill. Hi, everybody. My name is Halina Dziewit, and I want to tell you a little bit about my background, and I really appreciate you coming. And what you heard about interrupting is just fine, because I think that really will go ahead and help focus in on what you're looking at and what you want. And I may gloss over some things, and they may be important to you. So, feel free to go ahead and interrupt. What I wanted to go ahead and let you know is that my background, and I'm going to tell you, I started when I was 9 years old. I actually worked at Bell Laboratories, so AT&T for a while, and I actually did patent prosecution work at that time. That's where I first cut my teeth on intellectual property. And then I started looking at a lot of the transactional work, and so I moved to a company called Storage Technology Corporation, which you now know as Oracle, because Oracle acquired all the entities Storage Tech went through to go ahead and become a computer software company, both hardware and software. After that, I went to the National Center for Atmospheric Research, which is an FFRDC, which is a federally funded research development corporation. So it has government aspects to it, but it's still privately run. And I was director of technology transfer there. So, so fortunately for me, I got to be in industry, and I got to be in a federal lab, and I got involved a lot in technology development, technology transfer, technology licensing, and that was a great opportunity to see it from a commercial, industrial perspective, to go ahead and see it from a federal lab perspective. And then after that, I moved on to a firm called Squire Patton Boggs. I think they're one of the AmLaw 20 firms, and that was a great opportunity to go ahead and get international experience, major international experience on many things that had to do with technology and how to work through technology issues. Again, research and development, licensing, manufacturing agreements, distributor agreements, it's all there. And I mention those agreements because you'll see why as we get through the NDA situation. After that, I went to work for Lathrop Gage, which I believe is Lathrop PGM or something like that. I don't know what they are now, but I left before they merged. And now I work for Berg Hill, Greenleaf, and Rochetti, which is a small firm in Boulder here, but it has all the people that used to work in those big AmLaw firms and decided they wanted to work in a small firm environment. So that's a great opportunity to go ahead and really use my expertise and make it available in a small firm environment. I also belong to some organizations called Licensing Executive Society and Licensing Executive Society International. And this is an organization that I joined many, many years ago when I was first involved in technology transfer, licensing, and any kind of research and development agreements. I also belong to AUTM, which is Association of University Technology Managers, and I joined that organization when I was at NCAR. And that organization probably was one of the best places to learn about the interaction between universities, federal labs, and commercial entities. So that was the place that started this NDA that we're going to talk about. And I'm also a certified licensing professional. In that particular instance, you have to go ahead and take a test to go ahead and become a certified licensing professional. So again, remember I started when I was 9, so I just wanted you to know that. So that's really what my background is, and that's why I feel like it's important to kind of understand all those aspects, so this mutual NDA template makes a difference as far as how you interact with industry, how you interact with universities, and how you would interact with federal labs. So with that in mind, Phil, that next slide, if you can. Perfect. So what happened was I was part of a committee for LES and AUTM to go ahead and develop this template for NDAs. And basically what we were doing is we were trying to say, how do we go ahead and do something that's really simple, really straightforward, does not have any issues, and can get people forward and moving in their discussion with regard to technology and technology transfer. And so what we did is we said, hey, let's go ahead and try and put something together. Let's see if we can get these organizations that are well known in the transactional IP field to adopt these things. And these are much like, you know, as the slide indicates, we've gotten some basic agreements for like material transfer agreements and things like that. And we said, you know, the biggest thing is we don't want the NDA to serve as a total impediment to moving forward with technology transfer. And if we can get a template in place that seems to work, that would be great. This template has been vetted by a lot of people, but the main thing is that we think it has the essence of what an NDA is. Now, everything is not ideal. Things can get modified, things can change, but that's okay. We understand that, but this gives you a great starting point. So Phil, do you want to move to the next slide? So in this thing, I wanted to show you just how many people were involved from various different organizations, not only law firms, but folks that go ahead and engage in, you know, brokering technology, folks that are actually part of universities that do technology transfer. And this was the core group, but we actually had input from many, many other people in putting this NDA together. So we were trying to go ahead and say, again, what do we need to do that's basic that'll be acceptable? Next slide, Phil. Okay, so what we did is we basically said, okay, what is the basic template structure? What do we need to do? And how do we need to go ahead and make everybody happy? And it's very hard to do that, but we were trying. We were trying to say, hey, what do we need from an industry perspective? What do we need from a university perspective and a government perspective? And government is a very difficult thing to go ahead and deal with when you're doing with NDAs, but you do have confidential information, you have proprietary know-how, and you have to figure out how to protect that. Because if you're going to work with like NREL or any of those other places that exist around Boulder, you're going to need to know how to do confidentiality agreements with them. So that's what we were doing. And so what I wanted to go ahead and do is talk to you about that NDA, let you know that it exists out there and that you can go ahead and use this as a basis for moving forward. Phil, the next slide. So what we wanted to do is to let you know when we initially put this together, those were the number of universities or research institutions that went ahead and accepted this. And there are many, many more, but that's the initial list that we have. And so both AUTM and LES and LESi are accepting this NDA and saying this is a great starting point and we could probably move forward with this because it's got the essential components and characteristics and terms that we're comfortable with. And these universities are comfortable with them, industry is comfortable with them, and the government is comfortable with them depending on how you do your interaction with the government. It depends on whether you go through an RFP, you have a principal investigator and things of that nature. That's a little bit more detailed. That's actually another CLE, but it gives you an idea of the fact that this is something that's available and actually a number of universities are using. Okay, Phil, the next one. So what we wanted to do now is I wanted to go ahead and talk about the NDA and its various sections. And this is where I said, you know, if you have questions or if something comes up, please, you know, feel free to ask a question about this because there's various sections. We put this together. These are what our suggestions are. These happen to seem to work for most organizations, and they're not necessarily ideal. And all the folks that were on this committee didn't necessarily agree, but we think this is the best of what we came up with, and this seems to be going through as far as a lot of organizations are concerned. One of the things we wanted to do was to go ahead and, you know, because we wanted to get that buy-in, we did go ahead and do some things that might be a little bit different as far as how we might approach an NDA or what you're used to, but this is what we found to be buy-in. And again, everything is a little bit, you know, you can customize it a little bit, but it gives you a starting point. And so that's pretty important for everyone. So one of the things, and I apologize for kind of looking around here as my papers are falling a little bit. So one of the things I did want to mention about this non-disclosure before we get down to the particular sections is number one, there is, for some reason, everybody says, let's get an NDA in place. Well, let's think about really getting an NDA in place. Do you really need to have an NDA in place before you talk to someone? Remember, you're going to go ahead and you're going to do some speed dating. You might go ahead and think about maybe, you know, going out with someone, maybe getting engaged. You may enter into a commitment, but necessarily an NDA is not the way, always the right vehicle to go ahead and use when you're going to talk to someone. So, for example, I have a client that has a cannabis extraction system. And in that particular case, they said, oh, we have to get an NDA in place. And they were talking to like 2 or 3 manufacturers, you know, for a mechanical device. And we're going, well, wait a minute. Do you really need to tell them details? Do you need to let them know anything in particular? Or just do you want to see if they have the capability of making, you know, this type of device, an extraction device? And they said, well, yeah, we just want to see who we might want to talk to in detail. So in that particular case, you don't want to use an NDA unless you're really going to go ahead and explore a little bit with each other as to whether or not you should start dating. And that's the reason you want to do that, is because you don't want to get signed up to agreements constantly and have these agreements hang around for the next 2, 3, 4, 5 years, 10 years in some cases, if you're talking, you know, some of the bio industry, you know, information exchange, because you don't want to go ahead and have these, you know, in your system to prevent you from talking to other folks. So you want to go ahead and have NDAs in place when it makes sense, not just because it looks good on paper. You don't want to do that. So when you're thinking about an NDA, make sure that it makes sense, that it makes sense to talk to a manufacturer in detail when you need to, not just, can you make an extractor? And, you know, the extractor for cannabis, you know, that's kind of known in the industry. Some of you may know that personally, I don't know. But the whole point of it is that that's not anything that's necessarily confidential. You just want to get a feel, and then you decide whether or not you need to exchange some information. So I wanted to go ahead and bring that up and let you know that that an NDA isn't the be all and the end all. You're not passing them out like M&Ms all the time. You want to make sure that it makes sense for your clients that you're moving forward with. One of the things that I want to go ahead and talk to you about is also just generally the purpose of an NDA, and we'll get into details in that in just a few minutes, is the exchange of information. And that's all an NDA is supposed to be. I've had many instances where people will supply software under an NDA. I've had people that have supplied, you know, genome sequences under an NDA. And what they're doing is they're supplying information that should be under different documents. An NDA solely is for the purpose of exchanging information and the ability to go ahead and discuss that information and to determine if whether you want to go to the next step. And I've seen that mistake so many times because I've seen people lose IP rights. I've seen people, you know, run into issues with regard to saying, hey, they took my technology and there was nothing in there that prevented them from being able to control that IP that was in there. So the NDA has to be only for the exchange of information. And it's very easy to get caught up in things that don't look appropriate for that. For example, on the coronavirus, the MERS virus that first came out from Saudi Arabia, I worked with the Saudi Arabian government, the health sector of the Saudi Arabian government, and they gave it to someone else to go ahead and study the sequencing in there without putting anything in place like a material transfer agreement. They simply used an NDA, and they went very distressed because all of a sudden they lost some IP rights and they didn't realize it. And I'm not saying anything out of turn because there were a bunch of articles from the WHO that indicated that there was a taking of the technology that shouldn't have been there. That was several years back, but that's the type of thing that could happen if your NDA is used for the wrong purpose. So just remember, it's always being used for the purposes of exchanging information and nothing more than that. You don't have software protections such as don't, you know, reverse engineer or anything like that. Don't make improvements, don't make modifications. You're just missing a lot of things in an NDA if you're just using it for the purposes of exchanging information, and that's what you should be using it for. Okay, all right, Phil, next. The preamble. This seems like it should be really straightforward, right? You fill in the parties and you fill in the effective date. Let me tell you that what happens a lot of times is you fill in the wrong parties and you don't fill in the effective date. I've seen that so many times with clients. The parties have to be the specific parties you want to exchange information with. That's how your enforceability comes into play. I had one client that had a drug-eluting stent, and they said, okay, well, we want to talk to Johnson & Johnson. Well, I don't know if you're aware, but Johnson & Johnson is a huge company with many subsidiaries, many affiliate organizations. And so what we did is we said, hey, what part of J&J do you want to talk to? Because this, in essence, keeps your information in a more confidential situation. In other words, you control who's getting the information, you know where it went. It didn't go to all the J&J subsidiaries and affiliate organizations all over the world. So you really want to make sure that you are doing the right person. Also, if it's an entity, make sure that you have the entity. If it's an individual, make sure it's the individual. Also, I would recommend that you always have two folks involved, two parties involved. I've done NDAs. I hate to admit it, but I have had, 3 and 4 party NDAs. But what the problem with that is it starts getting messy as to tracking your information and trying to enforce who did what, who can communicate with whom, and it's just a very difficult thing. So it's always best to have a, 2-party NDA in my experience. Otherwise you run into problems. And I have seen that. Actually, I was involved in a litigation where we had too many parties involved in the NDA, and everybody was fighting over who came up with the technology and whose technology was involved. The effective date, I bring that up only because lots of times when you're talking, you go, okay, let's get an NDA in place. Let's go ahead and add the parties, and they forget to include the effective date. And the effective date becomes important because then it indicates what your obligations are, meaning that how long the NDA is in effect, that you can exchange information, and how long you have to keep information confidential. So even though this looks really simple, it does have consequences if it's not filled out correctly and with the right parties. Okay, Phil, next one. Okay, purpose. One of the things that you really need to pay attention to, and I was mentioning this at the outset, was that you need to go ahead and indicate why you're exchanging information. We gave you something called the alternate purpose description, but in essence, what we really want to do is say, why are you exchanging information? Why are you talking to someone? I gave you an example at the beginning, talking to manufacturers of extraction systems or extraction devices. Those folks, they didn't really need to get an NDA with everyone. They just needed to know, have you ever built one before? That's general information. So what you really want to do is you want to go ahead and define the purpose of discussing the information. Is it because you want to go ahead and start saying that you want to go ahead and start dating? You want to go ahead and enter into an engagement? You want to go ahead and get married? And that's what you're really looking at here. So this is the whole idea. And it also frames the scope of what it is that the people can do with the information, so you don't have a wide breadth of just saying, well, I can do anything I want with the information. That's not true, and that's not how you control it. This also helps if you have to go into court and you have to get an injunction and you have to go ahead and look for damages and things of that nature. Because remember, you're trying to control the information. You're trying to protect it from going to other parties. This is information that's critical to you. It gives you an advantage over your competitors, and it also, protects the information from getting out there. It's just like, who the Bachelor is going to go ahead and propose to at the end of the Bachelor series, things like that. You don't want that out there. It ruins the whole show. So you want to go ahead and indicate what the purpose of giving information is. And it's typically for the purposes of determining whether or not you're going to get into a further relationship. And it also puts you in that position of saying, okay, I think you guys have the ability to develop this software. I think you guys can move forward with the software, and let's go ahead and enter into a software license agreement, a limited test license agreement. and we'll give you some software. It also forces the client to go ahead and say, hey, we need to get another agreement in place because we have much more happening in the way of improvements, modifications, you know, potentially functionality. Maybe you don't have patent coverage yet, or maybe you just have a provisional in place. You know, so this gives you the opportunity to move on to the next agreement. So just go ahead and think about why it is that you're talking and what you're going to do after you're talking. But this is just for the exchange of information, and you'll see how it plays into effect a little bit later on. The optional thing about party 1 and party 2 representatives, that's typically when you have, you know, big companies talking to, for example, like a PI at a university or something like that. You want a point of contact. So if you have a big company, you know, like Microsoft, you would like to go ahead and have that person be in charge of receiving the information and making sure that they keep an archival copy or they know where the information is going. And then that's what you're trying to go ahead and do. Makes it easier when you go through a litigation process if you've got specific parties that come into play and you know who's being a gatekeeper for that information. Okay, next section, Phil. Okay, confidential information. This is one that all of us that were involved in creating this, you know, had a little bit of thoughts about, because a lot of people want to keep it very open as far as what the confidential information is, so they don't necessarily define it. I'm actually more of the opinion that I like to define the confidential information that's exchanged, as well as the field of use that it's in. So this is something that if I had a client, I would do the optional part, and I would also talk about, you know, fields of use. So for example, I would go ahead and say, hey, I've got some information here with regard to augmented reality. And I want to go ahead and talk to you about augmented reality and see what you have. You know, can you go ahead and construct the appropriate headgear for that? Can you go ahead and show me what the interface might be, without providing them, of course, any of the software, but talking to them about the technical aspects of it. And I would say that I would give you, you know, some concepts, some ideas. I might give you, you know, a little bit of information about how this augmented reality works in this environment. And I'm looking for it for gaming purposes or something like that. So I would really go ahead and define confidential information in a sense of saying, here's what I'm giving you specifically, and you mark every single item that you give them. And then here's the field that I'm looking in. And that way it makes it easier to enforce, because you've got an NDA that is very specific as to what you're doing. One of the things that we argued about was whether or not we do this reduction to writing thing within 30 days. And the main reason we're going to do the reduction to writing is because you don't remember what's happening when you're discussing things. And it doesn't have to be a big, long discourse of what it is that you provided them. Like you might have provided them some blueprints for something, just so that they could take a look at it and say, yeah, this is something we can build or something we can't build. But what it does is it says, this is my paper trail. This is to know what's going on. And it could be a very small summary, you know, with communications that we have both electronically via email, you know, text messages and things like that. And I do have a lot of clients that do text messages. You always want to go ahead and say, this is considered confidential. This is what we've got, and reduce it to writing. And it only needs to be a summary. But again, it's a paper trail. Otherwise, when you're saying, hey, this other party stole my technology, how are you going to prove it if you don't have something that indicates what it is that you've disclosed to the other side? And you've got to have a paper trail. And that's what it is. And that's why I also like to go ahead and define the technology and the field of use for that technology, so it makes it easier to go ahead and follow. So anyway, that's our suggestion there. So you can go ahead and kind of look at that and decide whether that makes sense or not. But for everything that I've seen, and I've seen people steal technology, I think it's very important to go ahead and have that definition of confidential information with a little bit more robustness as far as what it involves and what field it's associated with. Okay. Okay. Permitted use and protection of confidential information. This is where your purpose comes into play. Remember at the beginning we said define the purpose. So this says when you see these blueprints, your only purpose is to go ahead and talk to me about whether or not you can manufacture this particular, for example, an extraction system. Can you do it? Can you have access to suppliers that will give us this material? Do you have access to machinery that will go ahead and extrude the appropriate thing that you need extruded? That's what you want to do. You don't want them to use it for any other purpose. Again, I've seen this more of a problem in the software area because, again, people give software under an NDA and they think, oh, that's fine, it's not an issue. Well, that is an issue because you didn't tell them what they can do with the software. In other words, can they go ahead and tweak it? Can they interface it with other software? Is there other problems with regard to, reverse engineering? And so you want to make sure that you're telling them you can only use it for this purpose and nothing else. Also, the protection with regard to the information. You want them to make sure they're protecting it appropriately. Remember, people can access emails. Anybody can access, your text messages. It's just the way it is. So you want to make sure they have safeguards. And we usually say the same degree you would keep your information confidential. Let's go ahead and use that same care, but it's got to be a reasonable degree of care. In other words, don't sit there and write a piece of paper and just go ahead and, not worry about it, or have somebody touring your facilities and all of a sudden they see it. How, you shouldn't keep this out in the open. Like for example, if you were just looking at some blueprints, somebody can look at it walking through the facility and say, ooh, that looks like a good extractor, and walk away with it. So you want to make sure that you're exercising a reasonable degree of care to prevent that unauthorized use, disclosure, dissemination, and things of that nature. In the old days, we had a lot of things done in clean rooms. So what we would do is say, hey, you can go ahead and look at this in a clean room, but don't look at it anywhere else, because that's what's important. And that often happens with chemicals or crystals that you're making, or materials or anything like that. Very much go ahead and exercise caution to make sure there's not that exposure. Also, the disclosure, to people that need to be involved. Again, employees, consultants, lawyers, people of that nature. This is part of the arrangement, and this kind of makes sense. Now, whether you're allowed to go to subsidiaries or affiliates, again, that's where you use that beginning part of defining who can go ahead and get that information and who's party to this agreement. And if you have any of those people involved, it's got to be under the same terms and conditions as you have this NDA. So you want to make sure that whatever it is that allows others to access this information, that you want to make sure that it's covered. Okay, thanks, Phil. Next. This is where I mentioned about the terms of NDAs. Sometimes what happens is they'll say, okay, you have to keep things confidential, for the next 3 years from the date of disclosure. Well, what if the date of the disclosure happens to be one of the last days of the NDA? So does that mean there's 3 years after that, or does that mean that, it stops the day after? So this NDA is really important, and I've seen so many NDAs that people pull offline and they say, oh, this works. Well, it doesn't work unless you have a definitive time that the agreement is effective, and then the definitive time of how long you have to keep things confidential. This helps the clients. Otherwise, they've got non-disclosures all over the place, and they don't know when their obligations necessarily end under the agreement. So we tell you to go ahead and fill in those appropriate items as far as how long you can exchange information and how long that information is confidential. Typically, for most of the things that I do, I usually allow like 1 year to exchange information, because I've noticed a lot of people are kind of slow in exchanging information. And then for 1 year thereafter, they'll keep things confidential, and then you're done with it. Now, if you have trade secrets, you can add something to the NDA that says if it's a trade secret, but you might want to think about that as to whether it makes sense under this NDA. Again, you can customize this a little bit better, but this is just for general information. And also you have to think about your technology. Some technology moves very fast. And so you don't need long times that it's confidential. Some technology, they're giving you some information before example, they file a patent application which protects that technology. So it's a matter of really determining whether 4 years makes sense, 2 years makes sense. I'm an advocate, unless it's a specific trade secret or a specific situation, of really trying to go ahead and keep the exchange of information 1 year and just basically 1 year thereafter. So 2 years at most to keep confidential information. Okay, next one. Okay, there's exclusions, and I didn't realize that it was, I'm going to move as fast as I can now. There's always exclusions with regard to confidential information. What is it that gets you out of this if you still are under obligations of confidentiality? Okay, so, some of these are very obvious. If the person had it in its possession, the recipient had it in its possession before the disclosure discloses it, that's great. Now, here's where record keeping comes into play. You've got to keep records of your own information as well as information you're getting from other folks. And sometimes we had a clause in there that you can refuse to receive information if you think you're going to run into a problem, because you do have situations where people have taken things and it's an argument as to where that information originated from. And if you have notes and records, that makes a difference. Public knowledge without restriction. So for example, if they gave you some information and the prosecution of the patent finally became published, or the patent issued, public knowledge. And so you no longer have to keep it confidential. Rightfully received from a recipient by a third party. You have to be careful of the guy standing on the corner that has an overcoat that says, hey, let me give you something. Okay, you really want to go ahead and make sure that you get that from a third party. And that often happens in a competitor type area. Again, this is why you want to make sure that you keep a record of your information, and you want to make sure that your information is marked. But you can get information from other parties, and they had it rightfully to give it to you, and then that's how you can claim. I haven't seen that one happen that much, but it can happen in the competitor area. If the disclosure themselves go ahead and say, hey, I'm going to go ahead and publish an article in a journal that says all this stuff that I'm telling you now that I was wanting to be confidential, you're not required to keep it confidential anymore. There's also independently developed, and I mentioned something about clean rooms before, and that's what we used to have in the old days. And so what it was in that particular instance is that if you're developing technology that might be the same as the technology you're talking to with the other party, you better keep those developers away from this information that you're getting from that party. Otherwise, you're going to have a problem with determining who came up with what and whose idea was what. Again, marking things, keeping records is important, because you have to go ahead and show that you were the person that came up with this, and it wasn't based on the information you gave to the recipient. Again, the purpose of the information. So that's an important characteristic. The other thing that happens is also you might have a situation where you might have a court order or something like that, particularly if there's like data breaches, or if you're trying to go ahead and prove that this information really belonged to the disclosure, and you're looking for legal relief of some sort, whether it be equitable relief such as an injunction or something to that effect. You might get a court order for that. But what you want to do is to make sure that at least the other party is put on notice before you go ahead and disclose that. And you'll see that happening a lot as far as information, particularly I think when Microsoft was arguing with a company in Japan, they had these issues going back and forth. That has an international factor to it, but the idea is that you have to give enough notice. Okay, Phil, the next one. No warranty. This is important only from the sense that you're saying, hey, I have the right to give you this information. It really doesn't belong to anyone else. It is really our information, and I'm going to give you this information. The other thing is when I say it makes no assurances or warranties, or doesn't cause an obligation to go ahead and result as a result of giving you information. That's what you're trying to say here. And then that's important to know, because you're wanting to go ahead and say, hey, I have the right to give you this information, but I'm not letting you rely on it because I'm not in that position yet to go ahead and do that. We're just talking. We're just trying to get an understanding. This often happens when you're looking for investors. Now, there's sometimes investors, they will go ahead and say, well, can I rely on this? What do you have as far as a business plan or things like that? That's a little bit different situation. But here, what you're trying to say is, you know, I've got this, you know, extractor, and I'm going to go back to that, but there's no guarantee that I'm going to go ahead and enter into a manufacturing relationship with you. I'm not saying that this is not problematic, you know, because there's federal laws that govern, you know, extraction devices that have to do with cannabis or anything like that. So anyway, I just wanted to bring that up because that's what that no warranty section is. Okay, Phil, the next one. One of the things that we try and do in an NDA is to go ahead and say that if you go ahead and get this information, okay, there's no license that you get to the intellectual property underneath this. This is where it comes into play, where if you do accidentally give somebody a piece of software and you're saying, hey, you don't have the rights to any underlying IP, you don't have the rights to the patents, you don't have the rights to the you know, trade secrets that reside in the source code. You don't have any other rights, and you're not getting a license to those rights. If you want a license, or we want to go ahead and work together, we'll go ahead and give you a different agreement that'll going to come into play. That's also why material transfer agreements, you know, with regard to biological specimens are very, very important right now, because it has that language in there, and it also says what you can and can't do as far as the sequencing is concerned. And so this is just a very high level understanding of what it is they can't do, and they don't have any rights to anything other than to look at the information, to discuss the information for the purpose, and not get any rights to the information. They can't say, hey, that was pretty cool, but I'm going to go ahead and do an improvement and I'm going to get rights. Well, that's not what we're going to go ahead and allow. And that's what comes into play with this section. Also, we want to make sure that you go ahead and claim ownership of the information, blueprints, you know, papers, you know, quotes, and the information doesn't always have to be technology. It could be business information, such as, like, I was thinking of, you know, getting a strategic alliance with this company. Here's my financials. I'm looking to do a merger and acquisition and things like that. All that information remains the property of the disclosure, and this mentions that. One of the things that they do is sometimes companies will want to keep archival copies. And my personal opinion is I usually fight against that because people change, personnel change in companies. And especially if it's a very short NDA, it seems that, you know, because you kept track of the information, you should ask for that information back. I don't like archival copies sitting out there, because the people that are keeping the archive really don't know where that information is or where it came from after a number of years if it's a very long NDA. So I really am not a proponent of that, but that was one of the things that the majority of people that were involved in creating this NDA wanted to do. Okay, Phil, next one. Okay, this is basically neither party wants to go ahead and get information. I mentioned at the beginning, if you're really talking to someone that might be doing work for you and a competitor, then you want to go ahead and say, you know what, I'm not going to go ahead and do this, or I think you might be working on my competitor products, and I don't necessarily want to go ahead and provide this information. It gives you that obligation, and that often happens in universities. They're doing research and they're looking at, you know, various folks that are interested in the same technology, and they're often competitors. And they may say, you know, I don't want this information. And maybe you say, I just don't want to disclose this information because you're working for my competitor. And you just go ahead and realize that, because the last thing you really want to do is get into a struggle. And again, this document is meant to exchange information. And that's why you really want to be careful. You want to limit the information, you want to mark it, you want to monitor it. So that's the whole point. And again, there's nothing that says you have to get into an agreement with one another. There's nothing that says you have to move forward. You tested out each other, you did an initial blind date, everything was okay, but you don't want to move forward, and you don't have to do it. Just because you exchange information doesn't mean that you have to go out any further. So that's what this is. Okay, next one. Export control. I only throw this in there because I've had several clients that have had Homeland Security and a few other places come into effect where they were exporting data and information on their laptops outside the US. And this is a whole intricate area that really needs its own CLE, but what you're trying to do is you want to make sure you're complying with export control. And a lot of people kind of forget about that until they run into problem. There was a company in Boulder that was exporting to China some information in a particular industrial area, and they were giving them data, and they were giving them all kinds of information and blueprints and everything, and they were shut down because they didn't have the appropriate export control licenses. They were giving information to countries that were on the export control list. It's really a problem, and you need to have something in place to make sure that you're compliant with this, because export control, just like data privacy issues, you know, now what's happening in Europe and all the states in the US and everything else, you need to know the laws internationally so that you don't run into problems, because they will come and they will go ahead and shut your facility down, especially if you see that overtly. And this one small company in Boulder a few years back was just a small company, but it ran into problems with the US government because they were exporting the wrong information. So you've got to make sure that you know about this. And if you have this in there, that's part of your policies and practices that keep you a little bit safer. Next one, Phil. Injunctive relief. This is just saying, hey, folks, what's happening right now is that if I see you taking my information and using it inappropriately, not for the purpose, not only for the exchange of information, but for something else, I have the right to go ahead and seek all kinds of legal and equitable relief. And that's what I'm going to go ahead and do. That means that I can get an injunction, you know, because I think that you're damaging me by disclosing the information right now, and I can seek all kinds of legal relief because somehow my competitors found out about this and you ruined my market. And this is something that is typically in an NDA, because you want to go ahead and have the ability to immediately jump on anyone that's going to go ahead and use the information inappropriately and not for the purpose. And that's why that's in there. And then the next one, Phil. This is all that legal gobbledygook that you guys, you know, that we all see at the end of the agreement, which has to do with, you know, superseding existing agreements that might be in place. One of the things you don't want to do is say, hey, we were talking for a really long time and we considered all that stuff we did way back when as confidential information. Well, you know, this is superseding that. Now, there are ways to go ahead and you know, if you document and say, hey, we talked about this, this, and this, you might be able to cover it under this and say this is covered by this NDA. But basically, this is the document that controls the exchange of information between the parties. The other thing is that sometimes the NDAs are not assignable unless it's, you know, to another entity that basically buys the entity you're dealing with. And the reason is that, like, a lot of universities don't want to enter into agreement with certain entities. A lot of federal labs will not enter into certain agreements with other entities. And so they usually have a non-assignability clause in there. A commercial entity may not want the universities to go ahead and give it to another entity. So you say, hey, I don't want this assigned unless I know about it. There might be some situations that I want it to be assigned, and that's fine. And that's what you're looking for. And that's one of the things, by the way, when you go through due diligence, go see if the NDA is assignable or not assignable, because that runs into a problem, because you may have information that you're using with another party. You may have additional agreements. So as innocuous as it seems, sometimes the assignability can be a holdup in a merger and acquisition, for example. Also, you know, there's the normal things about waivers. If you fail to exercise rights, you know, does that mean you can never exercise rights? You know, things like that. And the signatures, make sure that they're authorized signatures. You'd be surprised how often you'd find that somebody that's signing the document, whether it be an electronic signature or an actual signature, is not the right person to be signing it. It's you know, like a lab tech as opposed to the PI that may or may not have the ability to sign. So you want to make sure that you have the right party signing this thing. And this is that stuff that you've probably heard about, apparent authority and things like that. So make sure that the right person is signing. And yes, you can go ahead and sign these documents via electronic means, not an issue. And also, one of the things that's optional is the state laws that govern this, because remember, this is a contract, and so it's usually governed by state laws. It's interesting, you would think that the federal labs that I've dealt with, and I've dealt with ones in New Mexico, California, here in Colorado, they will go ahead and say, oh, no, you can't pick the state law that's going to govern. Well, you can, but you have to know how to do it. And so that's a concern. The universities will always want their state law to govern, you know, like if the university's in California, they're always going to want California to govern, even though you reside here. So you want to make sure that when you find the NDA argument about, you know, well, we don't want any law to govern, you really prefer to have a state law govern, because if you get some odd place, and no offense against like Louisiana or anything like that, you want a place that really you can go ahead and have favorable laws that will help you move forward in enforcing this NDA if you're doing that. Okay, next one. So what we were trying to do, and why I wanted to present this, for those of you that are involved in universities or, you know, involved with negotiations with federal labs, we're looking to go ahead and see if this NDA is adoptable by various organizations. We're looking to see if this makes sense. And if there's other suggestions, we're more than happy to take these, but we also understand that the NDAs can be modified to deal with things like trade secrets and computer software and things like that. But then you're getting into other agreements. But we think this is a basic template, and we think it's a good starting point. And you saw by the accepting organizations that they find this template to be workable, and it is very workable. And I really haven't had much pushback from a lot of universities or federal labs or industry representatives on this NDA, particularly when you're really looking at just exchanging information. And Phil, next one. So anyway, I was trying to keep it to about 50 minutes on purpose because I wanted to open it up for questions. I appreciate your time, and I know I went through it a little bit quickly, but I wanted to give you just an idea. And part of the documents that you'll get is, you obviously get the presentation, but you also get the sample NDA that you can go ahead and use and work with if that helps. And then there's various sections in there. You can go ahead and embellish on those sections a little bit. You can go ahead and broaden them a little bit. But this should give you a template from which you should work, even if it's from industry to industry, and it's not overbearing. And that was the other thing we were trying to do. We were trying to make something that was basically just 2 pages long and didn't look intimidating, because I've received, probably like you have, like 5-page NDAs, but then they've gone beyond what it is that should be just a simple exchange of information. So with that in mind, any questions or anything?
I have a question.
Sure.
I was dealing with a scenario where one of the parties really didn't want any choice of law provision in an NDA. In your experience, can you talk about that issue and why maybe that request was made?
The reason they don't want a choice of law usually is because they are not necessarily domiciled in a particular state. So there was a Supreme Court ruling probably about 3 or 4 years ago that not a Supreme Court ruling, I'm sorry, district court ruling, that said there needs to be a nexus between where you have choice of law and where the contract is performed. And so you really do want to go ahead and push that. Now, the thing is that one of the solutions that I have had is that whoever it is that brings the cause of action first can go ahead and pick the particular place that they want to go ahead and have the law apply. But since each state has its own requirements and the UCC can sometimes come into play, you want to have that understanding at the outset. So I think what you do is, even though someone says, I don't want to pick a state, you say, well, let's pick a state. You can do a neutral state, and I've seen people do that before, like they'll pick New York or Delaware or something like that, or Nevada. But the problem is, again, there's that nexus to that state. So you should try and see if you can find a middle ground where you could say, okay, if you're doing business in the state and you find that that state is not problematic, then maybe you can go ahead and pick that. But I always, whoever it is that's disclosing the majority of information, I usually try and pick their state as the controlling state, because remember, they're talking to many people to try and deal with their one particular issue that they have involved. So I just try and push it. And most places will go ahead and back down. It's very seldom that I don't have an organization agree to a choice of law. And if the organization is really, really strict, like the universities in California, I know California law, so I said, okay, that's fine, we'll go ahead and deal with it. But mostly, just saying, don't pick, if you don't pick a state, then how is this going to be governed? And what's going to cause it to be governed might be an event that happens in a particular state, and you might be stuck in a state that you don't want to be stuck in, that might not be advantageous to your NDA. So it's just one of those things that you really try on negotiations to get that moving forward as much as you can. And if you can't, be the first to file. Any other questions? Okay. Okay, well, so anyway, I have my email. I think you can get through the Bar Association. And if you have any other questions, feel free, because sometimes when you're listening to something and you really just, get a little bit of, information, you want to go ahead and say, hey, I want to look over everything and get an idea, and feel free to call. I've actually mentored a bunch of students, and I've mentored some young associates as they move forward in the IP area, and then they come up with things after the fact. And I have no problem if you just call or email and say, hey, I've got some questions. What did you mean by this, or something like that? And that would be, that would be fine. I'm more than open for that. And sometimes there's not really exact answers, and you just have to be creative. And that's one of the things, actually, going back to my days with Phil, when we worked for the same firm, we would look at something and say, okay, now what do we need to do to be creative? We've got it. We've got this basic black and white document, and like, what do we need to do to make it move forward? And that's one of the things that you have to do as a lawyer. You have to think of a creative way to do this. So feel free to contact me after you look at everything and say, hey, Halina, this doesn't make sense, or this makes sense, or something like that, or how would you approach it? So appreciate that. Okay.
Well, thank you, Halina. That was a great presentation. So,
appreciate everyone's time.
And thank you, everybody, for joining us, and hope to see you at our next CLE event.
Thank you, everybody.
Goodbye.
Bye.